Justice Lewis, can you tell us a little bit about the merit retention process and what its function is, what its purpose is supposed to be?
Certainly, as I came through the public educational system, I learned about the old Missouri plan and the merit selection, merit retention of judges as an alternative to direct election of our judicial officers. And as I understand it, it was designed to enhance the quality of judicial officers and eliminate from that process, to the extent possible, partisan political considerations, to eliminate from the equation of having our judges appointed from those who best knew the executive officer and the appointing position. So it was an opportunity to have individuals vetted by qualified folks and select only those that were deemed to be highly qualified to serve the people. And certainly in a time as our communities became larger and larger, it's much more difficult for the citizens to personally know the judicial officers, particularly that may be seeking office, and particularly in our urban areas. In small communities where you virtually know everyone, it's a different story. But Florida has become so large that we've now reached about 18 million people. So I think that that was the original design, as discussed by Governor Ruben Askew at the time and Sandy Dalembert, who was in the legislature, and presented that to the people of Florida. And I think that was the moving force behind it, to enhance the quality of the Florida judicial officers.
And how does the election, the standing of election every, 4 years, 8 years, how does that play into that process?
Well, we now stand for retention each 6 years, which is the same term that even those trial judges who have direct election processes, the time period is the same. But our retention is to allow the people of Florida, if we have engaged in conduct that is not what one thinks ought to be the conduct of a judicial officer, as an escape valve, as a way to express that at in the voter's booth, not as a method of critiquing the opinions or decisions of a particular judge, but the conduct. Are you engaged in illicit activities? Are you engaged in improper activities? Are you engaged in unethical activities? Those types of circumstances that we would not want our judges to be engaged in, and it allows the public that access, is as I understand it.
Justice Lewis, in your usual political campaign, someone running for office can say whatever he or she wants to about the issues of the day, and most people think of that as a part of the electoral process. Whereas, of course, judges aren't free to talk about the issues that will be coming before them. How does that, what are those limitations and restrictions, and how do they impact this merit retention election?
Well, certainly we have a code of judicial conduct that all judges must follow, and it applies and has been interpreted in such a fashion that it becomes a very bland process from a judicial officer's view. And a judicial officer essentially, as we have now seen it, can become a virtual punching bag with the way in which political elections or campaigns are conducted today. And some of the most, I guess, disappointing things that I encountered during a contested merit retention campaign were the falsehoods that came about. But unfortunately, that's what we've come to expect from the normal partisan political campaign structure. And it just does not fit for judges to be engaged in that. And I think that it does harm to the perception, to the confidence that our people have in our judicial system. If it is just a battle of lies, then the public will not know what to believe, what to trust, what to think. And certainly with the First Amendment provides the freedom to tell not only the truth, but also to make misrepresentations during these campaign seasons, if you will. And it's very difficult for a judicial branch to become involved in that. And it's not only difficult for our merit retention process, but also the trial judges who face direct elections.
In this instance, and I may be jumping ahead, but in this instance, I know a number of members of the Florida bar became involved precisely because the justices standing for retention couldn't themselves speak out. Was that, can you tell us a little bit about that, and did that work to affirmatively avoid some of the...
Well, I think that it did. Initially, although the election was not conducted until 2012, the behind-the-scenes internet whisper campaign against us was started as early as 2010. The lawyers of the state were not immune from that information, and as they saw this occurring, they became more and more concerned with what was happening. And they understood that later on, that if this was happening at that time, 2 years before the election, it's unknown what would happen on the eve of an election. So the individual lawyers came to the conclusion that they could not wait until a month or 2 months before the actual election to try to help the public understand the importance of the merit selection, merit retention process. So they became involved and engaged, I think, early on, and the Florida bar, in an unprecedented step, came forward and attempted to provide information to the Florida public with regard to the merit selection, merit retention system. And I was very proud of the Florida bar with the program that they established. It was not in favor of any particular justice or against any justice. It was virtually an educational program, and I thought they did a wonderful job with that. And it was called The Vote is in Your Court, and was the best organized approach that I had seen the Florida bar undertake thus far in my legal career to any subject. And it was a uniform approach. It was well done. It was very professional and very nonpartisan and very noncommittal as far as any individual justice was involved. But I was very proud of the Florida bar, its president and its executive director. I thought that they just were magnificent in what they attempted to do for the Florida citizens.
My partner, Gwen Young, will be happy to know that
Well,
she was president.
She certainly was, and Ms. Young was fantastic in her efforts. She was tireless in crisscrossing this state to talk to people, to anyone that would listen, about the importance of maintaining a fair and impartial judicial system. The worst thing that we could have would be a partisan court system for our citizens to deal with. She understood the importance of that, and she carried the message as well as anyone I've ever heard.
Good, thank you. When did you first learn, you mentioned the whispers, when did you first realize that there was going to be an organized campaign, and how did that tie in with what happened in the Iowa Supreme Court?
Okay. I was not much concerned about the Iowa situation. The Iowa court had dealt with a highly emotional, highly political issue and produced a response, which happens in connection with the decision-making process of any court. The Florida Supreme Court had not engaged in any decisions that had such an emotional baggage with it or such a political overtone with it. But when I saw what happened to my colleagues, Justice LaBarga and Justice Perry, in 2010 in their retention campaign, I saw that there was a group that had fundamentally challenged the merit selection, merit retention process because neither of them had done anything to generate that kind of an attack. And then the first morning after the election, the groups that had mounted that charge and that had mounted that attack against them felt very, very empowered because they wanted to take credit for any reduction in the number of citizens who voted for retention without mentioning any other criteria, the small turnout, that we had a governor elected with, I think, probably maybe less than 1 million votes in an 18 million person state. And on that Wednesday, that group voiced that they intended that the next time around there are going to be 3 justices, and they were going to feel the wrath of this group who felt empowered by what had happened in 2010. So, to my mind, it was inevitable. They were going to mount some type of an attack on those, whoever it would be, that were standing for merit retention. Then, as time went on, the internet started carrying, and organized groups within certain partisan political parties started circulating emails. And I received copies of emails from my friends describing me as they were sharing with me what was going on, sharing with me the terrible things that were being said across the internet, and that they were asking their political allies to pass this on to as many people as they could. So we were under attack for much longer than most people may be aware. And then as these things were happening, the Florida Bar was starting to come together and understand the importance and the critical nature of the timing, and groups of individual citizens that had come together, which is appropriate under our code of judicial conduct, to support a retention election. They all started to come together probably 18 months to a year before the actual election, when they became really actively involved in trying to do something and meeting to decide what they could do, how they could do it, what were the legal steps that need be taken. So it was a full 2-year process. And I must tell you, I carried around in my stomach a rock for a 2-year period, because I care about the system, not so much me personally, but I want this system to survive long after I'm gone, because I believe in a system that strives to eliminate partisan politics from its control.
Did you talk with the other justices on the court, and particularly the justices who were likewise the subject of these emails?
Oh, certainly. It's unavoidable. I mean, we certainly knew that was happening, and we chatted from time to time. But we also encountered some problems with our code of judicial conduct that caused us to have to draw some very artificial lines with regard to what we could do or what we should do. I mean, we looked at the canons and took such steps that they became almost foolish. We would separate ourselves into different rooms and behind curtains so that we did not appear to be together, if you will, and supporting one another. Although you never heard from anyone's lips, please vote for me or vote for one of my colleagues. Our approach is that the system is what is really most important. None of us individually, but the system was absolutely critical to Florida's remaining where it was, because we remembered the bad times of the 70s. I was just admitted to the Florida Bar, and in fact traveled the state with a judge, Judge Shelby Highsmith, who's a fine man, a senior judge in the federal court, when we were still electing Supreme Court justices in the early 70s. So my memory of the problems and of the concern that Florida citizens had with the court back in the 70s were also there lingering in my mind, that how could we let a state like Florida, how could we lose something as good as a merit selection, merit retention process, fall back into partisan political hack politics? And that was something to me that was extremely important, whether I would be retained or not, because I still love the law, and whether I'm sitting here or I'm on the street practicing law, it's important to me in both categories.
You've mentioned the ubiquitous internet emails and whispers. There was advertising, wasn't there? Was there some lawsuits? And
that was probably the most difficult part to deal with, and that is the advertising. And because today's political campaigns depend upon that mass communication to such an extent, it's become extraordinarily expensive. And in a judicial race, with the limitations on the amount of money that individuals can put together to try to get a message across to the public, became impossible. We could not afford to run, if you will, campaign ads or materials in the metropolitan areas where it needed to be, because the cost was prohibitive. What's the alternative? It's the internet. And we used that to the extent possible, but so did the opposition. And in that, there was one case that was picked out by this group that troubled me to no end. And it was a case on which they absolutely out and out lied about what happened in the case. First, they represented to the people of Florida that this court had turned loose a murderer who had committed an awful act. Well, the individual defendant who had been convicted was not released. It was an issue of whether he had had effective assistance of counsel, and he was still incarcerated while that issue was being discussed. Most importantly, they represented to the Florida people that I had voted to turn this person loose when I, in fact, had dissented. And so how does one deal with that? You know, I didn't have enough money, and there's probably not enough money in the world to counteract an out-and-out lie such as occurred in that particular campaign piece.
Was that an email or?
No, this was an actual advertising, like on YouTube, and I saw it as a film, and I actually have a copy of it. Maybe I'll send it to you. But they were criticizing what our court had done, and it's true, we act as a court. And I say this not to criticize my colleagues in the way they voted, but I didn't vote the same way. Yet it was represented falsely. And that's an essential problem with particularly a judicial campaign when you don't even give correct information. So, and there's no way to correct it. There's no way to contact a TV station, as there would be in other campaigns, and point out the falsity, give them the material.
Ask for retraction.
Those kinds of things. So it was very troublesome to me, and it's the first time in my life that I had gone through that kind of process.
What else was going on? There was litigation.
Well, yeah, unfortunately, we had an executive in this state that ordered his police force, FDLE, to investigate us, and I felt badly for the officers who came over to confront us. I mean, they treated us in an interrogation as you would any other criminal suspect. But you could see they were embarrassed because we had nothing to hide. Nothing illegal had been done. And when they reported that back, that didn't satisfy the state executive. He made demands on the local state attorney to press for charges. And the local state attorney said, no, I don't believe so. Then we were sued not once, but twice. Finally, on the eve of the election, represented by a right-wing group out of Georgia. Filed a lawsuit under the nominal appearance of Florida citizens, but it's the same lawyer that filed two of them. And so that occurred. And it was never ending.
What was the lawsuit?
What the claims were the same in both of the actions, is that we were not qualified to sit or to be on the ballot, attempting to rehash all of those things that the Secretary of State had already cleared as far as what was what we had filed and how it had been filed, that all of those things were appropriate, and the courts so found, and the actions were dismissed. But it does not stop the turmoil that one feels, because there's pressure from that. And I'd never been sued in my life, and now I know how citizens who face claims in our courts feel. So I don't know. Maybe it was fate, and it would give me a new perspective on things. But it was one of those things. It's just disconcerting, because you never know what's going to happen when a matter enters a courtroom. You lose control of your destiny.
Yes, you do. At one point, as you know, the state Republican Party actually voted to oppose the retention of the three of you who are up for retention. Had that ever happened before, at least
No.
as openly as this was? And did anyone from the Republican Party ever talk to you about it privately?
No. Well, I mean, no one from the official, in an official capacity. But first, I mean, it was our understanding they took that vote. That's what the newspapers reported. That's what all the media was covering. And to my knowledge and my understanding, it had never been done before. In fact, it is illegal according to our Florida statutes. I'm not sure that's constitutional, but at least in the past it had been honored that the partisan political parties would not be involved, particularly in the merit retention kinds of circumstances that we face. But no, I did not have any conversations with anyone in an official capacity, but I had a number of very staunch Republican friends, those who were firm believers in the Republican Party views, that would call me and say, "I'm sorry this has happened. That doesn't represent my view." So I think that there were a good number of persons who may be registered as a Republican that were not in favor of doing this, and that it was a small group of the executive board or council, along with the top executive who is in charge of the party that would approve something like that caused that to happen. But I think it backfired. I think that may have been.
I was going to ask you, do you think that backfired on you?
I think that the Florida citizens being informed by the Florida Bar and having correct information and having information that we really don't want either party or any party, partisan political party, involved in our judicial processes, saw that was not the right thing to do. It would be wrong for a Democrat, a Republican, a Green Party, an Independent. You don't need and you don't want partisan politics in a decision-making branch.
What was the Republican Party saying as their reason for taking this position? I guess it's reported in the
I really don't know. I mean, I think certainly they were of a view that our decisions reflected something that they didn't approve of. I don't know that they pointed to any one case. They did not pick up the mantle of the one death penalty case. So I don't know that group set forth a particular case with which they were dissatisfied. So I really couldn't answer that question.
just general unhappiness.
Oh, I think so. Oh, yeah, I think so. And I think a general unhappiness that an executive had been thwarted in attempts to do things that were contrary to our Constitution. And when the court acted, as it must, that was considered an affront to a partisan political party whose top person was not happy about it. So
You refer to Bush v. Gore?
well, no. I think some of those were even after that, such as the governor came in and tried to change the administrative process and stop all rulemaking. We had those kinds of things that were coming in, and they took it very personally when it should not have been. And certainly they just sort of overlooked the things. For example, when the governor cut off the federal money for the train activity, the construction down in Central Florida, refused the money, said we're going to stop, even though a lot of money had already been spent, came to our court, and we agreed with the governor's view on that. So it's selective memory, it's selective discussion. And I think that there was a feeling that we were interfering with an agenda that was not appreciated, to say the least.
To say the least, very sure. How did to the extent you know, how did the members of the bar individually coalesce to support the merit retention process, apart from the Florida bar itself?
Okay. I think that most Florida lawyers, without regard to the type of work that they did, without regard to their own political persuasions, understand the importance of an impartial court system. And what swings today in favor of one side may swing tomorrow in favor of the other. and you don't want it swinging in favor of someone. You want it administering justice as best it can. So I think that it was an honest approach. I had defense lawyers come up that I had worked with over the years saying, I'm so sorry that you're having to go through this, plaintiffs' lawyers, estate lawyers. It was a broad spectrum of individuals that understand the importance of maintaining trust and confidence in your judicial branch. And if that's destroyed, I mean, we have nothing left.
And what did they do? Did they go talk to their neighbors, talk to the
Well,
press?
they formed groups, and those groups, they even did poll work, as my understanding, went out to the polls on election day and talked with people who were there. They talked to civic groups. They talked to their friends. They talked to other members of their own professional groups with regard to the merit selection, merit retention, and maintaining that as a process. Because if it should fall, the only alternative would be going back to direct elections, if that's what we're going to do. And I think they see the dangers, the real dangers in that.
Were you at all, you've mentioned people talking to you, were you at all involved in the efforts themselves and what should be said or done, or just kind of seeing it from the...
Each of us had a group of concerned citizens and had persons who had taken the leadership with regard to those positions, and they were on their own, certainly, but telling us what was going on, had taken the full load with regard to conducting a campaign, if you will, to do those things that are necessary to advance a particular cause and handle it in that fashion. But our code of conduct, judicial conduct, permits a committee of concerned citizens to do that. And it happens not only in our merit selection retention cases, but also in connection with our direct elections at the local level for our trial judges. Local lawyers are concerned and get involved, as we should, because if we don't do it, certainly lay citizens who don't understand the judicial process cannot be expected to carry that load.
Was all this activity and press and emails, nastygrams, disruptive and hindrance to you in trying to perform your obligations as a
Well,
justice?
you would like to say that it was not, but I think the honest answer is yes, it was. As I said to you,
human if it was.
right? As I said to you, for 2 years I felt like I was carrying a stone around in my stomach, just because of the uncertainty for the system. I mean, personally, I probably would have been much better off financially and for my sanity if I had gone back to my practice and just gone to do what I love to do, and that's being a lawyer. But to me, the stakes were far greater than just who's going to be on this court. It was for the structure of the court itself, and that to me that's the highest stakes. So yes, I was, and I was concerned, and around every corner. And you don't like people saying bad and nasty things about you. You know, you can say what you will, but to me, it's not. That's not who I am. I'm not that confrontational with folks. And as I went around the state after this was all over, and I said to the 30% or so that did not want me to be back on this court, come say hello, get to know me. Maybe I don't have the horns and the devil's pitchfork that you think I have. But it's disconcerting. I'd been asked to run for election for a judge at the local level before I came up here. And I'd always refused because I don't want to get involved in a political kind of election. And what happens? I turn around in my last term and I'm right in the middle of one.
Right in the middle of it.
So I would not recommend it to anyone for fun and happiness.
How did it affect your family?
Well, terribly.
Yeah, it had to.
I lost my youngest daughter during that period of time, and it just kept piling on. My father, who was 101, died during that period of time, and it just kept coming.
Good life.
Well, but it just kept coming. It wouldn't stop. It was just one thing after another. And so it had an effect. And it's unfortunate that these things do have effects like that, just like the invasion of the press with the Bush versus Gore case. Had a profound effect on me and my family with the invasion of just private things. But that's the price you pay to do the job, and I don't mind to do that. But things have consequences, and people do things and say things, and words do mean something.
They hurt. You mentioned going back to the 30% who voted against you, which means more than 60% voted for you.
Right.
Which is not appreciably different from the percentages.
That's right.
Unopposed.
That's right.
So what's the takeaway for you?
Well, unfortunately,
All this agony
well,
you went through. And,
from my perspective, those numbers would not have been the same had the lawyers of Florida and the Florida bar not mobilized, because misinformation, disinformation, and lies would have covered the state totally without a response. Now, whether we would have not been retained and fallen below 50%, I don't know that I can answer that question. But it troubles me that there are many lawyers that are going to look at this election cycle and they're going to say, see, I told you. But they're not the ones who understand the hard work that went into covering the state. During the summer months just before the election, I put over 7,000 miles on my car, going from Pensacola to Key West to Jacksonville to Tampa, to cover and try to meet as many people as I could, to talk to them about the importance of the system, the judicial system that we have today. So there was a lot of effort involved in that, and yet, I mean, really, people who are good friends say, I told you would have a problem. But they didn't see the inside. They didn't see what was really happening. So it troubles me that if this happens again, will there be those who will step up again and say, we're going to have to do something, or will they say, oh, nothing's going to happen because of our experience? So you are right. I mean, the numbers are about where they were before. But historically, 30% of the people of Florida vote to remove judges in each of the districts at this court and all courts. And it's just sort of, that's the anti-government kind of vote, I think, that's out there. But, thinking people who want to understand that you got to have some place to go to resolve your disputes, short of with guns in the street, understand the importance of having a judicial branch that's impartial, that's not controlled by the partisan politicians, and that where you walk in, theoretically, everybody has the same footing, whether you're rich or poor, big or small, powerful or weak. And it's a level playing field is what I think is most important.
Were you here when Justice Shaw and Justice Marquette stood for retention?
I was not on the court, but I was practicing here in Florida at the time, and I think there's a little different undercurrent at those particular times. Unfortunately, Florida has a very checkered and unhappy past, as far as I'm concerned, with discriminatory acts and the way that we behave in connection with things. And I think Justice Shaw had authored an opinion that had upset some folks, and I think that his status as an African American upset some people back at that time. And we're going back just into the 70s. Yeah, just back to the 70s. But the racial discrimination in the state of Florida was not unique in the 70s. And then, of course, we had the aspect that we had a female on the court. And there are those who use the gender discrimination as well, and also her ideas. A bright judge, a good person, but she also had authored some opinions that folks just were not comfortable with. So we didn't have that this time because we didn't have any hot button issues. So it was unlike the Justice Marquette's and Justice Shaw's merit retention elections, because we didn't have those. Now, if we had an overlay of some hot button issues and had the overlay of a non-presidential election with a smaller turnout, who knows? I mean, that's a risk. That's a danger of this process. but I think the numbers turning out made a difference as well. We had a far better turnout during this general election than we did, for example, in 2010 when we had the gubernatorial election.
And so the just sheer numbers of people coming out
Makes a difference.
makes a difference.
Makes a difference, sure. And it makes a difference what other issues are on the ballot. Are there some constitutional revision proposals on the ballot that have special interest groups that support them? I mean, this thing called political elections is becoming a real scientific, technological, business kind of approach to things. That there are ways you do it and ways you influence it that folks would never even really think about. It's not simply John Smith and Mary Smith walking to the corner to vote. This country and the state have moved far beyond that, and so those are issues that we have to be concerned with as well.
Do you think that notwithstanding the good result and the defeat of the effort to turn the three of you out of office, that there has been a lasting harm to the court, to the process?
Oh, I think that any time that an institution suffers a body blow, may not be a knockout punch, but suffers an impact, that yes, there are lasting injuries that flow from that. Maybe not overwhelming, and maybe not ones that would destroy an institution, but yes, there are lasting injuries to that. And that being is that the only thing that we have that really makes any difference is the trust and confidence of our citizens. And if that's damaged, if we lose one, then the next time maybe we lose two. Those are real damages. That's real harm. And when you turn on the TV and you see people telling lies that here people are turning folks loose for no reason, I mean, what do they think?
Well, and doesn't that, you mentioned you never wanted to stand for election, but now you've in essence had to stand for election with your,
And my mouth closed.
Your mouth closed, you couldn't say anything, and where is that going to lessen the enthusiasm for good qualified people to serve in the Supreme Court?
Well, the thing that concerns me, we have to be mindful that to leave private practice and enter a judicial branch, that you are leaving behind your life. You're changing your life totally. And I could not now go back and replace all of the clients that I had 15 years ago when I stepped from private practice into the Florida Supreme Court and support my family and the law firm that I had at that time by stepping back on the street now. So I changed my career. That's really what it is. It becomes a career change. I not only changed my career, I changed my community in which my career was going to be conducted. So you have to be careful and mindful of those types of things. If we would look at, for example, just maybe we'll just do it one time and then leave, well, then you're getting the worst of all. I mean, serving one term and then it's over. Well, that's the worst of all worlds, because the only people that would do it would be those who want to wear the badge of the prior office and think that people may think that you have an in with somebody because you used to be a Supreme Court justice, and that to me projects the wrong image. So I don't know what the final answer may be, but I think that if we get in these battles each time there is a merit retention election, that yes, it will cause some qualified individuals to make that decision to, I don't need this. It's not worth it. Because, most lawyers, I find that although the practice is changing, I find that most lawyers truly who have a good practice enjoy their cases, enjoy the people on the other side of their cases, and it's a little more complicated and complex now than it has been over the years, but they love being a lawyer. And why does one give up what you truly wanted to do with your life to go do something else when it's just going to be nothing but aggravation? You know, it's just we sit here, we do the best we can, and then we're shot at by everybody who has an opinion. And you dodge so many bullets, one of them's going to hit you right between the eyes one of these days. But that's what is troubling to me. How do we attract the very best, the brightest, those who are impartial? How do we do that? And I think that to date, the merit selection, merit retention, if we get our judicial nominating commission process straightened out, is probably the best answer that I have seen, short of lifetime appointments. The lifetime appointments of the federal courts, of course, they have their own problems and associated issues. So I'm not sure that when you're dealing with societal issues, conditions of the human mind, that you ever have a perfect one. So what we have to strive for is to try to get the best system possible that delivers the most justice, that provides the best trust and confidence that we can provide to the people of Florida.
Well, that leads to my next question, which is, now that you've had all this hindsight and lessons learned and bloodied but unbowed, what should the right merit election, retention election process look like?
Well, I think probably that something along the lines of a judicial approval commission, if we could ever exclude the partisan politics from that type of process, that we would have something on the backside that would be similar to the judicial nominating commissions on the front side. When I was Chief Justice, I appointed a large commission to study this issue at the urging of several members of the bar, that we need to look to see if there's something that ought to be done in fact, I think it maybe was a member of your firm, the former Solicitor General, Tom Warner, was one who wanted to talk about that. Jerry Richmond, who's very active in bar matters, they both approached me and said, I think we ought to have something. Would you explore it? And to me, it made sense to at least study it. And so we had the commission. They worked for an entire year on trying to determine whether there ought to be some type of body that we could use to make the recommendations on retention. And I think Colorado has started down that path. And at the end of the day, after that commission met for the entire year, met several times, had speakers come in, studied it, had position papers, looked at it all across the nation, concluded, all except one, that we should stay the way we are.
Stay the course.
Right, to stay as we are without that type of body that would participate in making a recommendation on retention. But I think probably we have perfected the merit selection. The question is, how do we, in some way, or should we in some way, perfect more perfectly the merit retention part of that equation? But the finest minds that I could put together, representing all sectors of partisan political views, of lawyers and all kinds of different works and lay people, they came up saying, you have it about as good as you can, but that was before this last merit retention election. So I don't know that today they would all say the same thing, but it has been explored, and that was in 2006, 2007.
Well, but I wonder, you do raise an interesting question. These are different times, and I wonder if that's something that the court may want to look at and say, is there, because you're right, it is the retention process that caused the problems.
Sure.
Here. To that end, is education of the public the answer, do you think?
I don't think it's the total answer. I think education of the public is certainly a component part. I'm a huge advocate for full information and for education at all levels. It's got to start in our schools and come forward in our schools, and we cover this in our justice teaching program that I started. So that's the first place that you start, and then you continue on up into other groups and to the adult community as well. We have so many transplanted Floridians. We have them not only from other countries, but from other states. And this merit selection, merit retention process is foreign to them as well. And so they don't understand how it's supposed to work or why we have it. So education is a key component. Is it the end-all be-all? Probably not. So I agree with you that anytime an institution suffers something like we just experienced, that it's not a bad idea to take a look at it to see if there's something else that ought to be done to tweak it. But I would not be in favor of convening a group that would want to go back to direct contested elections, because that to me is the worst of all possibilities in today's climate. The manner in which campaigns are conducted today, to me, are just below cesspools.
Did you talk at all to any of the Iowa Supreme Court justices?
We did.
About
We
their
did.
experience?
Right, we did. In fact, one of the justices came down to speak at an historical society function at the dinner that the Historical Society has each year. And we had the opportunity to meet and chat with that justice. And that justice has shared with us the fact that the members of that court who were up for retention did not have any organized effort to resist what was happening. And before they knew it, on the eve of the election, they were under such attack that it was impossible to recant or to go back and repair the damage that had been done. And again, it was an emotional issue. And the way things are going in this nation, I think those hot button political issues and emotional issues are the ones that create the greatest danger, because it is just a response. It's an automatic, like, knee-jerk reaction to it, rather than thoughtfully looking at what a jurist may or may not have done over a lifetime of service and how he or she may have voted in one case. I mean, it's a human system. And as we look back we look back over the last 50 years, what may have been thought to be a great decision at one time, then in hindsight maybe it's not so great, or ones that we thought were terrible may end up being wonderful opinions that were necessary to who we are as developing as Americans in this democracy. So those are all things I think that become involved as you look at a process like that. But you see every day what's happening on the national scene as well, with partisan political activity. It's becoming so partisan and so split in such terrible divides that it seems as though we really can't come together for much of anything, and that's troubling. Because really, fundamentally, beneath all this stuff, get away from all this. You go meet with your legislators back in our hometowns. These are great people you have coffee with, have breakfast with. Yet when they get to the center of government, they take on a partisan approach that seems irreconcilable with other views. So I think it can be done, but I guess that the report that President Washington sent to Congress, he's reported to have told them in his resignation letter that the largest danger to this democracy was partisan political parties. And maybe we're experiencing that. I don't know. I hope that things may change a bit, and as reflect upon issues that we need to cover some ground that benefit all of us. But certainly we can't have this bloodbath over our courts or judges. That ought not be one. That ought not be the area, because it does do harm. It does do harm.
It sounds clear that the Iowa experience with it, catching them, if you will, by surprise when it's too late to do anything, really shows the wisdom of people starting, members of the bar and the Florida
Right.
bar, starting early in this campaign, and I wonder if that's something that you would talk to your colleagues about who will have this coming up. Who are the next ones?
The next ones up will be Chief Justice Polston, Justice Kennedy, and Justice Labarga and Justice Perry. So we have 4 coming up the next cycle coming around. Also, it's interesting that we're having such large groups from the court sitting at one time on the retention. 3 of us were in 2012, 4 in 2010, and it'll continue in that mode for a while. You know, we had at some point we'd have 1 or maybe 2, but never have we had the majority of the court all sitting for retention until modern days, until 2010 actually. So that makes a difference. And yes, I would share full information with any justice, any judge who cared to listen or wanted any information, because I believe that I have an obligation, even in connection with their elections, to help educate the public. And whether I agree with what they say or don't say, and I cannot endorse them because of the canons of our judicial conduct, but I believe that I would have an obligation to go speak to public groups to tell them what merit retention is about. And it's not a referendum on whether you agree with their opinions, but it's a question on the process. So that's how strongly I believe in it. And now that I'm in my last term, because I become constitutionally senile at the end of.
So you won't have this fun anymore.
No, this is unfortunately I'll miss out on the fun of having to do it again. But I think it's so important that all judges should be able to speak about the system and why we have it.
Did the other justices, including those that weren't up for re-election, did they go and speak to public and citizens?
Only Justice Perry, and he wrote a broad editorial that was circulated to all of the major news outlets in the state of Florida. That very carefully pointed out that he did not endorse any of us, but the importance of the merit selection, merit retention system. And he did it very artfully and very well spoken in the way it was presented. It was done in a very non-political way, and he was the only one that stood up, because there's also was a danger because when Justice Shaw was up for his retention, there was a district court of appeal judge who came out in support of Leander Shaw, and he was actually sanctioned by this court after a Judicial Qualification Commission complaint. On that. It was a judge in the 4th District Court of Appeal, and it was Hugh Glickstein, and he did it as a civil disobedience, because he saw the attacks on Justice Leander Shaw as being racially motivated. So he felt it was his obligation to speak out in his favor, and he was disciplined for it with a reprimand. He was not removed from office, but so I respect that Justice James Perry wrote those editorials, or that editorial that was circulated widely, and I think it demonstrated his strength of character in connection with this and his belief in the system.
Did you talk with Justice Quince and Justice Perry the next day?
Oh yeah, that night we had chats quite often as the results were coming in, and as we watched with concern as the TV continued to report what was happening, and our faces grew happier as the evening went on, and finally reached the point that 2,000-pound stone in my stomach was gone. But we did.
Was in doubt once the vote started coming in.
Well, that's the way it demonstrated. But again, if we had not had the support of the lawyers and a great many of others across the state of Florida, I don't know what the result may have been, and I fear that it could have been something that would have been a nightmare for the future. The most important thing is don't underestimate. Do not underestimate the intentions of those with partisan desires. They will go to any lengths, any extents to accomplish what they see as their goal. And I think those legal actions that were filed against us, they were reprehensible. I see the complaints that were filed when someone's concerned about who notarized my oath of office that I swore that I would uphold the Constitution of Florida and the United States, and I look with all other officers, virtually every judicial officer and state attorneys had their assistants notarize that, because it's not participating in an election. And it's the furthest thing from your mind. It's just that you think someone is merely acknowledging that they know the individual and this is who signed it. And a notary has never commented upon what is the content of a document by merely acknowledging a signature, yet that was used as attempted to be used as a lever, a weapon to attack when no other legitimate basis existed. So I think that's what I would pass to someone else. Don't ever underestimate the depth of these partisan feelings. That it's a great danger. So maybe I take a little counseling from our first president that just has no place in what we do.